Same one for orders.
Yeah. Have you filed your affidavit as directed by this court on 27? Have you seen the order of 27/9/2024?
Yes, Lordship.
Have you seen the order of 27/9/2024? You are newly engaged.
Yes, Your Lordship.
There's an order passed by this court to file an affidavit. You go to the affidavit through the order. Order is going to give all. Order is very clear. You file an affidavit in terms of the order. How much time will you require?
Okay. Your Lordships, actually, I have limited the instruction from the petitioner, and the only balance amount is of rupees 4,08,000, which comes under the head of domestic help allowance.
Earlier, you were claiming 25 lakhs. On that 27/9/2024, you came down to 15 lakhs. And today, now you are saying 4 lakhs. That's why this court said.
As per the chart,
That's why.
it's applicable and accepted all over.
That's why this court on that 27/7/2024 passed an order asking you to file an affidavit. You filed that affidavit. We'll give you 1 week or 2 weeks time. It's up to you.
But Lordships, we don't have any other prayer. Just we
Is a-
have just a limited prayer.
It's a judicial order. Yeah, 27. Oh, this chart we have seen. This chart we have seen. You don't have this 27.
This is the total amount. The bank have already paid 47 lakhs 84,400, and the balance is 4,08,000.
According to the respondents, they have cleared all the balance.
But if
according to you, you are still to get some dues. So on that basis, we asked you to file an affidavit.
your Lordship may dispose of the contempt petition, let them examine the chart.
This is a contempt. We don't pass directions. Either you satisfy us.
Lordship, they provided a chart. According to them, Your Lordship, they are entitled to more of rupees 4,08,000. And they are praying for that their bank may examine this calculation sheet and pass the necessary order. If they are entitled, then it is payable by the bank. And they are praying for closing the matter.
This is my limit. This is the limited prayer.
Oh. No. This charge is made by you.
No, Lordship,
No,
it's prepared by
by
the
the petitioner.
Then we take your instruction whether they are supposed to get it. What MSJ Vice Chair and Council for the
Your Lordship, kindly fix this matter day after tomorrow.
Okay. Who submits that the petitioner is that the total amount payable to the petitioner at this stage is rupees 4,08,000. Huh? Stop. Mr.
H. Buragohain, Lordship.
H. Boragohan and its council for the bank,
State Bank of India.
for the State Bank of India shall take inspection. Based on 23rd.
Obliged.
Obliged, Your Lordship.
Yeah. Yeah, with Majumdar.
But the affidavit, we are filing, is on the verge of filing matter. The
Lordship,
FDS
by the
affidavit.
last order, respondents were directed to file a affidavit and we were supposed to give a reply.
You're given 10 days time.
My lord, I was given but lapse on my part and I received the sworn affidavit yesterday.
Okay,
Yeah,
let
we
the
can file
affidavit
today
come.
itself.
They are filing.
Lordship, may fix up this matter for Monday, Lordship, or Friday, because Lordship, one of the clauses in the poem which he had submitted last time, it says, Lordship, that they had granted time only for 15 days, they had opened the portal, and next 15 days they would be extending it. But that portal itself,
Yeah.
that portal itself is very defective, Lordship. On the last occasion, I had shown it to
Okay.
two lordships, how they have made the portal, Lordship. A child who is applying from Kamrup district, there is not a single school in Kamrup district which is registered. When the drop down list comes, schools are shown in Nagaon, Matia, Jola, in other states. There are so many schools here, but none of these schools. So the child is not legible to register himself or to take admission under 12(1)(c) in his own place, Lordship, within a radius of 5 kilometers.
Okay,
Therefore-
what we'll do,
Yes,
we'll,
Lordship.
we'll give a short date,
Yes,
get
Lordship.
the affidavit on record and we'll carry us. You're you're the petitioner in person?
I am petitioner in person in this
Or-
matter. Lordship,
the-
let him serve me a copy today. We will file a reply and let it be fixed on 25th, Lordship.
Mr. R. Majumdar, the standing council,
Department of School Education.
Department of School Education submits that he'll be filing the affidavit. He's filing the affidavit within the course of the day. Accordingly, is the matter on 25th June. You serve next, advance
Much
copy.
obliged, Lordship.
Pledge.
48 days. 47.
Yeah, I'm seeking a day's time, my lord. I'm filing my affidavit on Monday. It can be taken up on the Tuesday or Wednesday. I'll have it filed on Monday.
My lord, these are all statutory prescription. Let delay be on the matter be taken up on Monday.
Cannot be, my lord. Bishop will have a look at the application itself. Cannot be. It's defective and
Okay,
therefore I was
okay.
praying for just a day to bring it on record after that.
No, my lord,
Done, it is
my
done.
lord,
There is
end
no-
of the, I was pursuing a remedy
Party
bona
and the
fide.
affidavit.
The learned single judge has given liberty.
For party and the affidavit. That is where I would start. I'll bring in other affidavit.
Then you argue, well, for that you don't need an
I
affidavit.
just bring in an affidavit. Did it be-
No, you argue.
When are you filing?
I'll file it on Monday. Today it is coming from Dibrugarh. It's from Dibrugarh, my lord.
So my lord, the last time also time was taken.
Chaudhary, just
Yes.
the affidavit at page 9.
Affidavit, my lord.
And the signature at the end, the swearing date on the top of the lines.
The affidavit would Abdul Adhut Mullah.
Abdul,
Adhut Mullah. He is said to be the applicant,
Applicant.
but the signature is of somebody else.
And the applicant is someone else in the memo party in the.
I think there is some mistake in the affidavit. Mansoor Ali Ahmed is the applicant.
appellant.
Applicant also, but the affidavit is filed by one Abdul Ahud Mullah. The father of Mansoor Ali Ahmed is Nizamuddin Ahmed. Some mistake maybe in the page, some other pages.
Anyway, say to it. my lord.
The applicant and the
On Bonaute, you took 2 months time. That's it to भूल.
signature are different.
No,
Maybe it's in 2 page. It's in 2 page. So maybe you just check up Gautam.
Yes, let it come up. Let my junior check up, my lord. Yes.
take remedial action also in the meantime.
I'll take remedial action, my lord. Let the matter come up on Monday.
Okay. The applicant shall take steps to remedy the defect in the affidavit at page 99 of the present article. Page 9. This Monday?
Monday.
So you can't take up.
My lord, as far as the main case is concerned,
Chaudhary,
yes.
Technical problem.
Oh, yes, yes.
I appeared in.
Yes, yes. I'm sorry, but I forgot.
List this case. Before any other bench, without one of us. We should take it. Just-
Let it come after the vacation. I think Monday also same
After
constitution. Let it be after vacation.
After vacation, after 21st or 22nd.
I'll say after vacation, it'll take some time for it to come up.
The Lordship may give a date after 21st, Miller. Any date?
Okay, please don't. Give your date, give your date. Convenient date, both of you.
23rd or 24th.
Okay, okay.
24th.
কোন তারিখে খুলিব?
issues still pending.
14.
Some issues, these issues for a long time, and the other one is that entry tax matters.
Let it be 21st, any day, man. 23rd, Miller.
23rd or 24th.
Okay, 23rd.
Highly obliged. And this provincialization also, it was settled, but again, we have filed a review application. So again, that issue will come. Division bench. Highly obliged.
4 and 5.
Right?
Same.
No, no, 4 and 5.
Okay. For any other. Or nothing should be raised up.
And 6.
Ma'am, please, Your Lordship. My lord, yeah, my lord, we have a sale.
May I please, Your Lordship?
That's you.
Index to good. 90%.
Yeah.
In my class. Too late. Take it.
Actually, and we should.
Before my learned friend starts, Lordship, I have received a copy 3 days back. I am yet to file my power. Lordship, but my name has been shown as response number 10 in the cause list.
You take your seat.
My lord, here the nutshell of the case.
Lordship, in this case, I would like to file an affidavit.
Das, please have a seat.
My lord, here is the case, my lord. The petitioner was working as a high school teacher, my lord, and his college, her service was provincialized. Then, my lord, private respondent number 9 filed a writ petition without making me party, my lord. Accordingly, my lord, my service was withdrawn from the provincialization. So they have passed in speaking order. I challenged before the honorable single judge, which has been rejected. Now I am before your lordship against that order. That order, your lordship will see at page. It starts from, my lord. Starts from, my lord, 190 of the impugned judgment against which I have come. In 11 to 20. Page, my lord, in IA, lordship will see at page 11. Yes, sir.
No.
Operative part starts from 11. of the impugned judgment.
Yeah.
In that writ petition, my lord, a speaking order was assailed particularly. And the Honorable Single Judge said, my lord, that until and unless I challenge the judgment where I was not party, so my case was discarded, against which I have given lordship. And lordship has seen the operative part last 20, my lordship can see para 16. Though the Mr. Borvia learned counsel for the petitioner submits that the petitioner is not aggrieved by the order dated learned single judge, yet in the view of the categorical stand taken by the respondent number 5, as also respondent number 9 and 10, this court is unable to record the concurrence of the submission of the mail. Under the circumstance, the court is inclined to hold that writ petition is not maintainable in the present form. Accordingly, the stands closed without going into the merits of the case. However, liberty stands reserved to the petitioner to avail appropriate legal remedy to her under the law ordered accordingly. And now, my lord, I challenge the speaking order in that particular writ petition.
What is wrong with this order?
Order, my lord, I have challenged particularly my speaking order. And they said, my lord, there is already order.
There's already a judicial
There is
order.
no judicial order. Their lordship, they have wrong interpretation, my lord. That judgment I have annexed, my lord. Lordship will see at page, my lord. That judgment never interfered my case, my lord. But,
In the affidavit in opposition, they've annexed the order.
I have annexed in my petition also, my lord.
Actually,
Lordship will see in the, they have annexed, my lord.
huh,
Page 33. But if your lordship take up the memo of appeal, there, my lord, I have annexed, my lord. Memo of appeal at kiman page? Is it good to? 158 to 161, my lord.
in your appeal.
Yes. Lordship kindly see 158 to 156.
That is then the affidavit in opposition.
Yes, yes.
also.
Against this case.
Because, my lord, I have
Against this 404, the original judgment of Justice Bujar Barwa, which was complied with the provincial. In that case, I didn't challenge any of my colleagues' provincial. I was bothered only about my
152
provincial. And court directed
अरे याते मत
to be
करा से ना
provincialize me, and I was accordingly
What about
provincialized. Some time took it. For non-provincialization, in spite of court order, I filed a contempt petition and consecutive learned single judges, my lord, asked the government, why are you not implementing? Why are you not provincializing? Then ultimately, I was provincialized. I was provincialized. So far as this judgment is concerned, by virtue of this judgment, 4041, against this also, at the appropriate time, they had ample opportunity to come for a review, which they didn't.
My lord, let me
No,
make
my
my
lord.
submission,
No, my
my
lord.
lord.
No.
Let me complete, my lord. He'll
All
get
that
ample
is-
chance.
He will go into the facts, but only 10 days ago, he filed a petition praying leave to challenge this judgment on which your lordship issued notice 4 weeks.
That judgment we
Already
challenge
notice already
separately,
issued.
madam. That is altogether different, madam.
That is.
Now,
no,
my
that
lord,
is-
against
that-
my
no,
impeached
that-
judgment.
No, that challenge. This
I
Justice
challenge.
Buzar- yes. Lordship 143 of my objection in I. Your lordship's order passed on this month. He challenged this order. Yes, page 143 of the
Clap for you.
affidavit in opposition in I. I received notice. Yes. Justice Buzar Bora's my lord judgment and order.
Let it come along with this.
My lord will see, my lord. Lordship, my lord will see only one thing, my lord. I'll just pray before
And I'll-
lordship. Lordship, kindly permit me 5 minutes time, my lord. The judgment passed by the His Lordship Vijay Borough, my lord, at page 159. That's it. 159 operative part, lordship will see memo of appeal, my lord. Page 160. That will clear the picture, my lord. 160, my lord, of memo of appeal. 160. Operative part, my lord, I'm reading, it starts from, my lord, 158. Operative part is reading, my lord, 3 paragraphs I'll read, my lord. Para 9, my lord, para 9, lordship kindly, I'm reading, my lord. We are unable to understand the stand taken by the respondent in as much as the petitioner was appointed on 38 2003, whereas the Pratima Chetia, that is myself, my lord, was appointed on 2005. To under what circumstances the petitioner can be said to have been appointed against the access post, under what the fourth incumbent was appointed against the non-existing post. Further, the stand taken in the earlier writ petition was considered by the assistant professor against the elective subject. Lordship, kindly mark this point, my lord. Elective subject. Elective subject, whereas the others were considered against the SME subject. Dibrugarh University under memo number so and so to the additional affidavit to the provided that the SME is elective subject and SME subject are two different subjects. I am SME subject, two electives. If that so, two different subjects, the right to be provincialized included in favor of the petitioner to the provincialization as an assistant professor, SME as an elective subject. But I am not elective, my lord. If there is elective, there is another post is there where it has gone. Their claim was,
Will not get a petition. Otherwise,
my lord,
there is a mandamus issue there.
lordship,
Not a consideration.
what I pray before lordship. Yes, I agree, yes, his lordship, my lord. A short date may be given, my lord.
List this matter.
Well, 4 weeks time I have got. I have the opportunity of this order, my lord, that you have lordship first order, my lord.
Noon, na.
Leave, praying for leave. Praying for there, I will have to objection. 143 order, lordship.
That's what we'll.
My lord, that is only for the provisional, my lord.
4 weeks.
Lordship will have to pass order in my rate appeal. Whether
will
that
pass.
order was right or wrong, that has to be examined.
List this matter along with IA within brackets civil 1704.
Number
2025.
Lordship fix that for tomorrow, my lord.
No. Yeah, I will give my, I have time to.
No, my lord, I am not arguing on that case, my lord. I'll argue in this particular case.
We have it on 25th of
636, my lord, it was issued, 4 weeks time was given, that is yet to come. I will file a reply to this also. Same subject.
after the summer vacation.
So it will have to be.
My lord, they are enjoying, my lord, at least some interim protection be given, my lord. They are taking my salary. They are enjoying my.
When your appeal is by itself not maintainable, how can you pass an interim?
My lord, if
We
it
have
is,
to view.
Yeah.
That first order will have to be challenged.
that is already challenged, but that order did not say anything against me, my lord. That's why I am insisting to
That's
lordship.
already a direction.
Lordship will see the page 161, my lord.
Yeah, call out, make it.
Lordship fixing the date, my lord.
My
After
lord,
summer
along with,
vacation.
it will have to be after vacation because 4 weeks we
My
have
lord,
time.
after vacation, it will
No,
be
no,
put
I have
down,
time.
right?
4 weeks last, as
We
per
can't
it.
help it. We can't help it.
All these cases,
Lordship fix the date, my lord. in the-
number, my lord.
Fix the date, my lord, and it is-
Number, my lord, 5747. Serial number, no? It is serial number.
IA is that IA will have to be considerable.
I have 1704. Same subject matter.
Madam, you just write down that.
She will give my lord. Along with, well, it will have to be after
Yeah,
vacation.
read appeal filing number, isn't that?
Yes.
Read appeal filing number.
Your lordship passed the order, gave me 4 weeks. 4 weeks are yet to come, my lord. I will have to object that also.
Yeah.
She had an opportune moment to
That
come.
is
for a
the
review.
buying time, my lord, nothing
Not
else.
buying time, it's my right. After vacation, not immediately on the reopening, my lord.
Lordship fix the date, my lord. Any day lordship fix the date.
4-5 days after vacation.
21st.
3rd week of September.
May I please, Lordship? Lordship, by invoking, may I please, Lordship, by invoking section 14 of the SARFAESI Act, my lord, the UCO Bank has approached before the district magistrate for, my lord, page 26, my lord.
Sharma, you have any?
I have just, please, your lordships, I've just received a set of paralyzed comments, which doesn't say anything other than the order dated 28/10/24, appearing at page 26 of your lordship's brief.
But it has to be complied with, my lord. The Supreme Court clearly says within 60 days the outer limit, my lord. Judgment is very much clear. It's a ministerial job, my lord, nothing, my lord. Lordship may fix a time, my lord, out of which, my lord, respondent number 2 and 3 will execute the order, my lord. They will, my lord, have
How
to.
much time do you require?
2 weeks time, my lord.
Yes, my lord, no problem.
Private is there.
Oh, respondent number 2 and 3, my lord.
Respondent 4 is there.
My lord,
Respondent 4.
my lord, he's a party, my lord. Notice has been served to him. And my lord,
Notice is there.
respondent number 4 is the borrower, my lord. My lord, that's the service we have taken care of, my lord.
Borrower who has lost before the tribunal.
Oh.
This is not issued here, Mr. Chamari.
We have sub notice, my lord. I'll check.
This is not gone from.
No, no, that is our record.
It has gone, my lord. 7/4/25.
This notice is up to 28.
Otherwise, my lord, the job has to be done by respondent 2 and 3.
Right of appeal.
Oh.
Right.
Right of appeal and as a.
What?
We'll pass it to 2 weeks time.
My lord.
Complete.
Respondent number 2 and 3, my lord.
Okay.
May I please, your lordship? Lordship, the IA has been filed praying for condonation of a delay of 30 days in filing of the writ application.
Hey, private respondents, no. RKD?
Lordship, that notice were at this stage because in the meantime, Lordship, it is relating to guidelines that has to be issued.
Is a delay.
Yes, Lordship, there is a delay, then I would be objecting to the delay petition, Lordship.
See what's the objective. 30 days.
Lordship. At least my client has to be put on notice.
Heard, Mr.
NN Datta.
Leonard Counsel for the applicant. Issue notice. Mr. Arkadin Chaudhry Leonard, Deputy Solicitor General of India. Appears on behalf of all.
No, Lordship, except for fourth.
Appears on behalf of the respondents. 1, 2, 3,
5 and
5,
6.
6. No. You want to file objections
Lordship.
and praise for how much time?
Let it be after the vacation, Lordship.
Yes, praise for 2 weeks time for filing objections. The applicant to take steps for service of notice on the respond number 4. You are appearing for?
We were initially impeded as interveners in the writ petition. We have also been impeded as intervener in the writ appeal, but surprisingly, the delay petitioner copy has been served upon us. We have not been impeded as party.
No,
Has to be done.
no, who appears for 4?
For Mr. Pathak had appeared.
So BIS is
BIS.
Mr. B. Pathak.
Then can you record his name?
Yes.
Okay, petitioner applicant to take steps for service of notice on the opposite party number 4 by registered proceeding within 1 week. List after summer vacation.
May I just since we have been impeded in the writ appeal as intervener, we may also be impeded here.
That you take steps.
Thank you.
We confirm it.
Madam Deputy, order.
If I don't have 13 number, 13 number.
Item 15 is connected with item 13.
Item 9.
Be it please your lordships. One of the appellant before lordship was an officer of the Food Corporation of India. He was compulsorily retired. And that order was challenged before the Honorable Single Judge, which the reputation has been rejected. My lord, if I may take your lordship to the order which was impugned in the writ petition, that your lordship will find at page 124.
Yeah.
It's a very cryptic order, my lord. Whereas the undersigned is.
Chowdhury will have to issue notice.
My lord.
Will issue notice.
Yes, my lord. Your lordship may admit, my.
Okay, good.
Admit for final hearing.
Yes, appearing someone by.
Heard Mr. M.K. Chowdhury, Leonard, Senior Counsel. Assistant Prime Minister,
Ruptim Borpatro Gohai, RB Gohai.
RV, go ahead. For the applicant. Who is he?
Lord, I am appearing for all the respondent, my lord.
Mr.
BK Singh, ma'am.
K.C. Leonard. So, Standing Counsel.
Yes, my lord.
Standing Counsel, FCI, appears on behalf of all the respondents. It means, release the matter for hearing after 2 weeks.
Oblige, my lord.
Or you want it a longer date? After
No, my
some
lord, I want
application?
shorter date because my lord, he has got long years to go. In the event, my lord, this appeal is allowed, he will be retiring in 2031. Oblige.
Item 10.
Now, please, Lordship. Lordship, this matter will be taken up on Friday, Lordship. Earlier, Bishop Property was appearing in this matter, Lordship.
Okay, on request made by MS R Division that
Lordship.
then a list after the summer vacation.
Lordship,
You have
before
been-
summer
You
vacation.
have been adjourning the matter for quite some time. We'll have it after summer.
Oblige.
11.
Manoj Kumar.
My lord, my humble submission would be merely because, my lord, there is no dispute regarding simultaneous proceedings. But when the charges are same, when the list of witnesses are same, my lord, there are judgments from right from Paul Anthony, Kushweshwar Dubey, then J.M. Tang's case. If your lordship will kindly come
But
to
the
the
criminal proceeding is under suspension.
Yes. No, criminal proceeding is, but there is no charge sheet, my lord. The disciplinary proceeding also, my lord, they have only appointed an inquiry officer. Just one paragraph, if your lordship will kindly come to the impugned judgment, my lord. Page 137, my lord. And eventually, page para 24 at 141. Since the original, at page 141, Miller, since the original application has been filed challenging the memorandum of charge sheet dated 25/6/24, as well as the order dated 17/3/25, whereby presenting officer was appointed, we have carefully perused the charge sheet and the said order. Upon such perusal, we do not find any illegality committed by the respondent, either in issuing the charge sheet or in appointing presenting officer, nor is there any violation of Rule 18 of the CCA Rule 65. Applicant has failed to substantiate his contention regarding illegality or procedural irregularity in issuance of charge sheet. Our case is, my lord, since the charge in the criminal case and the DP is one and the same, and by the same set of witnesses, they kindly see the list of witnesses, my lord. If your lordship will kindly come to page number 152. These are the witnesses, my lord, which are supposed to adduce evidence on behalf of the department. Pankaj Saran, Deepak Das, so-and-so Subhash Chandra Singh. Well, these are all witnesses in the charge sheet also. For example, my lord, Deepak Das is a co-accused. Then this Subhash Chandra Singh is witness number 3 at page 143. Then Arjun Kumar Moria is witness number 101 at page 151. Then my lord, Biswajyoti Lohkar is witness number 23 at page 123. KK Singh is a witness number 102, page 151. So when the charges are same, when the same set of people are sought to be, engaged as the witness, then Supreme Court says you can't. And look, in fact, in JM Tang's case, what had happened, in the disciplinary proceeding was concluded. The man was, my lord, the penalty was awarded. In the meantime, my lord, in the criminal case, he got a clear acquittal. And the language which has been used by the Supreme Court is, it would be unjust, onerous to hold him departmentally guilty once he has gotten acquittal in the criminal case. The reason being, my lord, they followed Paul Anton, where the charges are same set of persons are sought to be listed as witness. So therefore, my lord, the learned tribunal has not even addressed. Nobody says, my lord, that simultaneously no two proceedings cannot be held. It can be. But the only exception as carved out in Kusheshwari Dubey and Paul Anthony is when it is based on the same set of charges.
We'll issue notice.
My lord, they have only issued the presenting officer. They will not proceed, my lord, till the returnable date, my lord.
No, there is stay, lordship. What happened? I will place before lordship. Lordship, kindly go to page 136. You were solicited also. And page 136.
Yeah.
Also gone through the charge sheet filed by the CBI. The relevant para of the charge sheet which needs to be discussed in the light of the argument made by the applicant is here in under. The charge sheet was issued. Page 37, lordship. Paragraph 23. From a perusal of the two sets of charges, one in the departmental proceeding and other in the criminal proceeding, it is evident that charges framed against the applicant in the departmental proceeding pertain to misconduct, that is misconduct, committed by the applicant, constituting violation of rule so and so of the Central Civil Services rules. On the other hand, the charges framed in the criminal proceeding primarily relate to offences punishable under Section 120B of the Indian Penal Code, read with Section 7, 8, 9, 10, 12 of the Provincial and Corruption Act. Accordingly, these charges yes. Yes.
But cannot was saying they was also because rights will be prejudiced in the criminal proceeding. On the criminal proceeding is under state. But if we will not, then we will will consider. No stay. Because the prejudice angle.
Yes. Moreover, one thing is there, charge sheet is not annexed.
Lord, to reply to my learned friend, my lord, we are not disputing that they have annexed the charge sheet. Our case is, it is the same set of allegations.
You are appealing for?
For 1, 2, 3, lordship.
Oh,
All the rest.
MS,
Arbor.
Standing Counsel, NHAIDC. Oh, NHAI. Appears on behalf of all the. Although there's some defect in your.
First I think 1 or 2 days. 1 or 2 days, 1 days.
We'll file a memo, my lord.
First title will 1, 2 days, 1 to 2 days.
কিয় তোমালোকে বোলে ভুলবিলাক কিয় হয় হা ইটোতো এফিডেভিট ভুল ইয়াতে ভুল কোনটো
My first title
For the petition. Petition of
1, 2, 3, 1.
Standing Counsel, NHAI.
1, 1, 2.
এইবিলাক চাবা এইবিলাকতো মই চোৱা সম্ভৱ নহয় নহয় সেইটোতো এফিডেভিটৰ নামেই ভুল হৈ আছে চন্না লগাইছে এখন ফাইল কৰি দিয়ক
admit it.
Yes. My lord, only thing is, my lord, in the meantime, if they proceed, that will be subject to the outcome of the case.
After summer vacation.
Yes. My lord, it's a very small matter, my lord. It's on a very narrow compass. It can be disposed of on the next day. If they want to file anything, let them file it.
Item 12.
Within 1 week.
Yes, my lord. I'm sorry.
Yes, within by Monday, my lord.
Yes, by next Monday we'll file.
12.
May I please, lord, my lord, in this case, my lord, while sale auction notice was issued, my lord, by the respondent bank in SARFAESI proceeding, my lord, petitioner, my lord, filed SARFAESI case number so and so, my lord, but thereafter, my lord, while nothing was done, my lord, petitioner approached this honorable court by filing, my lord, WPC. My lord, kindly see page 46, annexure E1. Yeah. Relevant portion, my lord, page 48, last line. In view of the above, without expressing any opinion on the merits of the claim and counterclaim of the parties, would dispose of the writ petition by providing that the learned DRT may take up the application filed by the petitioner under section 17 of the SARFAESI Act 2002 on merit and pass appropriate order therein. Until such time an order is passed in the application, the respondent bank shall not confirm the auction sale. But my lord, in the meantime, on my lord, 18/7/24, possession of the flat of the petitioner, my lord, has been taken. Thereafter, my lord, petitioner filed another application, my lord, page 50, annexure F, miss case 658/2024. 50, my lord, 50.
Yeah.
Challenging, my lord, the position of the, my lord, bank by the bank on 18/7/24.
Oh.
Without, my lord, considering this petition, my lord, without disposing this petition, my lord, the SARFAESI case has been, my lord, decided against the petitioner.
The DRT.
Yes, my lord, DRT.
Is your application.
Yes.
Do you have an appellate authority?
No, my lord. Kindly see, my lord, page, this judgment, my lord. Order of this honorable court, my lord. Page 48, 49. In view of the above, without expressing any opinion on the merit of the claim and counterclaim of the parties, would dispose of the writ petition by providing that the learned DRT may take up the application filed by the petitioner under section 17 of the SARFAESI Act 2002 on merit and pass appropriate order.
Considered by the DRT. Your application was considered by the DRT.
No, my lord, this application has not been considered, my lord. My lord, want to kindly see, my lord, section 17(4), my lord, 17(4) of SARFAESI Act. If the DRT declares the recourse taken by the secured creditor under subsection 4 of section 13 is in accordance with the provisions of this act and the rules made thereunder, then, my lord, then only, my lord, notwithstanding anything contained in any other law for the time being in force, the secured creditor shall be entitled to take recourse to one or more of the measures specified under subsection 4 of section 13. But, my lord,
Section 18.
18 is there, my lord. Yes, my lord. But violating the honorable court's order, my lord, and without considering this petition, my lord, page 50, annexure F, they have taken the recourse, my lord, of possession of the flat of the petitioner, my lord. That is the case, my lord. Hence this petition. So without consider, my lord, kindly this.
How do you say your IA was not considered?
Last page, kindly see my lord. 73.
Yeah, we are on 73.
Yes, my lord. Last page, my lord. Accordingly, essay number so and so is dismissed and disposed of. There is no order as to cost. IA, if any, pending, stay and dispose of without any reason, my lord, without discussing anything, my lord. So, my lord, this was not considered.
We can't accept it. You approach on the 1680 before the applicant practice.
My lord, my honorable court's order is there, my lord. And
No order. DRT has considered matters. Your ISO was considered and sports. Now you have one object. You approach the appellate tribunal.
yes, my lord, that is there. That's correct, my lord. But my lord, without considering my miscase, my lord, challenging the position of my flat, my lord, that was not considered, my lord. That should have been considered, my lord.
My lord, your lordship may come at page 67. The heading is essay number. So, Honorable Dayati has considered every aspect of the matter. Admittedly, the property was mortgaged and the bank has taken possession of the property. So, if he has any grievance, he can approach the DRAT. There is a statutory provision of appeal. Under section 18, he can appeal.
But my lord,
Yes.
while my lord, the honorable court's order is there, my lord. How my lord,
That order was passed when 2023.
yes, my lord. But
When did you file your miscase? 2025
yes, my lord.
was a miscase. There when the court passed the order in 2023. You are trying to mislead this court.
No, my lord. My lord, kindly.
See one thing. You withdraw, approach the appellate tribunal, or we are dismissing this with cause. It's your choice.
Udo, my lord.
Mr. Arias, Let's put withdrawal of this. With liberty to approach the order. Which name?
A Parvez.
A Parvez.
This number 1 to 5.
1 to 5. With petition substance for withdrawal, with legal testimony.
Oblige.
13 and 15.
Bad pleasure, lord. My lord, the appellant before your lordship, he is in the grade of 6. Now he is agreed by his supersession to the grade of 7. Now, my lord, I'll place the promotion policy 3 paragraph, then I'll come to the impugn order. If your lordship should kindly come to page number 179.
You're on item 15.
13, my lord. I think 15 is the IA. If your lordship should kindly come to 178. That's the promotion policy, my lord. Page 178, my lord. Please come to 179. Now, the promotion policy, my lord, clearly delineates the different steps involved in effecting a promotion. So there cannot be any confusion. Kindly see, my lord, 6, determination of vacancy. Then, my lord, will kindly come to 7, broad criteria for promotion. May I read 7.1? The organizational needs by way of promotion of officers from one scale to another shall be fulfilled in such manner that the merit is appropriately recognized while seniority is duly respected to the extent consistent with the efficiency of the organization. So, my lord, it is not a case where per se merit is applicable. It's a case, my lord, I'll submit during the course of my brief submission, my lord. Merit and suitability with due regard to seniority. Then, my lord, will kindly come to page 180. Clause 8. Eligibility and zone consideration. 8.1 at page 180, my lord. For empanelment for consideration of promotion to the cadres of 6 and 7, an officer should have completed a minimum of 2 full years of continuous service in the existing cadre, subject to the provisions of para 17. Then, my lord, will kindly come to next page, page 181. 9. Qualifying benchmark for consideration of promotion to various cadres. 9.1.1. All officers in the eligibility cadre in GIC, ZIPSA, member companies, empanel as per para 8.1 for consideration of promotion shall be interviewed by the screening committee comprising of 4 or outside experts in the field. So, my lord, merely because you come into zone consideration, that does not mean you will be immediately considered by the promotion committee. You will be screened by a committee. So, it speaks of screening. Now, what are the attributes to be taken note of? 9.1.2. The screening committee shall assess the officers under the parameters of conceptual level, vision, depth, and range of overview of industry, economy, planning, ability, decision-making, ability, management traits, positive attitude, problem-solving ability, including conflict resolution, management, overall leadership ability, etc., and submit their assessment recommendation to the promotion committee. So, my lord, this screening committee is tasked with the duty of making recommendation based on these overall attributes. Then, my lord, will kindly come to page number 185. Then comes the ultimate selection by the promotion committee. 13.0.1.3. Promotion committee shall select officers equal to the number of vacancies determined as per provisions under para 13.0.1.1 or so and so promotion for placement in scale 6 or 7. We are concerned with 7, as the case may be. Now see, based on overall merit, suitability, growth potential, length of balance service, qualification, service experience in functional area, and seniority of the empanel candidate as may be assessed from performance appraisal and other records. So, my lord, seniority does not loses its relevance merely because I am empanel. That is where the learned single judge has gone wrong, I'll say, my lord. Now, the learned single judge has formed the opinion that the seniority would be relevant only for bringing you within the zone. That's not the position here. Then, my lord, will kindly come to the next page. Promotion from cadre of 6 to 7 and 6 to 7. 5 to 6, 6 to 7. Eligible officer after being interviewed by the screening committee as per 9.1 shall appear for an interview by promotion committee. The promotion committee shall, after taking into account assessment recommendation of the screening committee, overall merit, suitability, growth potential, length of balance service, qualification, service experience in various functional areas, and seniority of the candidate as may be assessed from performance appraisal record as well as personal interview. Prepare a list of officers selected for promotion. Now, my lord, as far as seniority is concerned, my lord, and the lordships may kindly come to please come to page number 101, my lord. Towards the bottom, serial number 35. Boam, Lothran bomb, zone of consideration 4. That means, my lord, I was in the seniority list, I was at serial number 4. Next, my lord, as far as the merit part is concerned, there is no dispute. My only grievance is, my lord, no weightage was given for seniority. My lord, lordship knows in service jurisprudence, we are, as we know, my lord, there are basically 3 criteria of promotion. One is seniority cum merit, other is merit cum seniority, and third category is merit and suitability with due regard to seniority. When it comes to seniority cum merit, my lord, given a particular benchmark, whosoever senior, he will steal a marks. When it comes to merit cum seniority, my lord, given the particular benchmark, my lord, the senior will steal, even a junior may steal a marks, where seniority would only play a role to the extent of making him eligible to enter in the zone. But when it comes to merit and suitability with due regard to seniority, each of the 3 has a distinct, my lord, role to play, where seniority has to be given a weightage. Now come to the impugn order, my lord, at page 501. Para 41, sorry, my lord, page 500, sorry, my lord. Page 500, para 38. Towards the bottom, at page 500, on bare reading of clause 13.1.1 clearly reflects that an eligible candidate after being interviewed by the screening committee would appear before the promotion committee for interview. The promotion committee shall, after taking into account the assessment, recommendation of screening committee, overall merit, suitability, growth potential, length of balance service, qualification, service experience in various functional areas, and seniority of the candidate as may be assessed from the performance appraisal record, as well as personally prepare a list of candidates selected for promotion. This is not the view of the learned single judge. This is what follows from 13.1.1. Now, this is important. Thus, in my view, while seniority would be a factor entitling a candidate to fall in the zone of consideration, but once so empaneled, selection for promotion would be based on merit, as promotion policy shows that it provides for a structured and merit-oriented framework for career advancement aimed at rewarding performance, fostering leadership, cultivating a professional, etc., etc., etc. Is it the correct position? The learned single judge has formed the opinion, my lord, in my humble submission, not correctly, that by virtue of seniority, it will be material as far as determining the zone. That's not the thing, my lord. Here, all that is required is I must be in grade 6 with 2 years of service experience. Then, my lord, there will be screening. Screening committee will make recommendation based on factors mentioned in clause 8.1. Then, my lord, it will be referred to promotion committee. And promotion committee will also take note of seniority, apart from other factors. Now, our case before the learned single judge was, my lord, the seniority factor was not given note of. The weightage of seniority was not. Otherwise, my lord, I meet the merit. For example, when it comes to merit, my lord, if your lordships would kindly come to page 119, for a moment, my lord. please. For example, my lord, comment on performance of the appraised and give appropriate rating. Excellent performance on all front and on track of achieving targets given. Page 119, my lord. This is the comments of the reporting officer. Consistently maintain profitability at branch with a possessed and professional approach. Company's image and standing is maintained in a small and competitive market. Comment on general state, etc. Sound. Then Milord will kindly come to page number 121.
120 next page.
Yes. Milord, the type page is 121. Yes, he should be promoted and is well deserving. Then Milord will kindly come to 123. A recommendation regarding suitability for other spheres, suitable for any sphere. Page 123. Then Milord will kindly come to 129. So in the middle, Milord. Yes, he can take higher responsibility. Then Milord will kindly come to page 141. Reporting officer same. Excellent performance on all front, on track of achieving targets given. Then finally at Milord, page number 145. Thus, appraisee possesses special characteristics or outstanding merit or ability which would justify his or her advancement and special selection for higher responsibility out of turn. Yes. So as far as merit is concerned, Milord, there is no dispute. All the materials were annexed. Now the only thing is the weightage qua seniority was not given. Now the learned single judge was of the view that the seniority would be relevant only for bringing the incumbent in the zone of consideration. Is that the correct position under the promotion policy? Prima facie.
Who is the order? Impute order.
Yes.
These 241 is subjective.
Before that, my lord, one page. If your lordships would kindly come to page number 231, my lord. In their affidavit in opposition, what they say. Page 231, my lord. Last 5 sentence of para 40. Page 231. It is submitted that promotion at such higher levels are subjective in nature. When the promotion policy envisages objective standards and criteria, they say it is subjective. So themselves admit, my lord. Now, as far as the impugn judgment is concerned, my lord, I have already shown that paragraph.
Order. Impute order.
Yes, impugn order is at page, lordship will kindly come to page 500. Para 37. It starts at 484, my lord. Lordships may kindly come to page 500. On a conjoined reading of the above provision reflects that the promotion of officers from scale 6 to 7, with which we are concerned, shall be within 6 GIPSA member companies on the basis of single seniority list of all officers in scale 6 in all 6 companies taken together. Promotion shall be based on sole criteria of merit. Candidates within the zone of consideration for promotion shall be interviewed by the screening committee comprising of 4 to 5 external experts from relevant field, including but not limited to management, human resource, organizational behavior, public administration, economics and psychology. The committee shall assess candidate based on various parameters such as conceptual level vision, depth and range of overview of industry, economic planning ability, decision-making ability, management traits, acumen, positive attitude, problem-solving attitude, including conflict resolution abilities and overall leadership ability before submitting its a recommendation to the promotion committee. This is as per the prescription. There is okay, Miller. A bare reading of the clause 13.1.1 clearly reflects that an eligible officer, after being interviewed by the screening committee, would appear before the promotion committee for interview. The promotional committee shall, after taking into account the assessment recommendation of the screening committee, overall merit, suitability, growth potential, length of balance service, qualification, experience in various functional areas and seniority of the candidate, as may be assessed from the performance appraisal record as well as personal interview, prepare a list of candidates selected for promotion. This is also, my lord, regarding the prescription in the policy. Now the view of the learned single just starts. Thus, in my view, while seniority would be a factor entitling a candidate to fall in the zone of consideration, but once SWAM panel selection for promotion would be based on merit, as the promotion policy shows that it provides for a structured and merit-oriented framework for career advancement aimed at rewarding performance, fostering leadership, and cultivating a professional culture of excellence, accountability, commitment, while seniority is thus duly respected. Records reveal that promotion exercise has been undertaken, taking into consideration all parameters of selection of candidates for promotion from cadre of scale 6 to 7. Altogether, 47 scale 6 officers in the zone of consideration were screened and interviewed. Promotion committee appears to have conducted an objective assessment. They themselves say subjective, my lord, based on all the above parameters in determining the final selection as performance appraisal records of candidates of 6 years as per a part of the promotion evaluation and allotted marks on record, work, external assessment, seniority, and interview has been considered. It is seen that work record constitutes of major contribution, institution building, health, integrity, general assessment, outstanding work, and fitness. It also reveals that Administrative Staff College of India, Hyderabad, was engaged by the respondent to conduct the screening of the empaneled officers. Records further reveal that each of the parameters were assigned marks and candidates were awarded marks based on their performance against these parameters, and total marks obtained by each candidate were arrived at, and the selection and promotion has been effected. Thus, an objective assessment of all parameters that enables the promotion committee to evaluate the candidate for promotion to scale 6 as 7 cadre by applying the same norms to the eligible 6 officers appears to have been undertaken equally in terms of the promotion policy. In course of hearing, having found that equal marks have been awarded to the candidates on seniority from serial 4 to 17 of the final mark sheet, this court posed a query to the respondent as to how equal marks were awarded to those candidates when petitioner is senior to the others at serial number 5 to 17. To his respondents have submitted that equal marks are awarded to empaneled candidates from serial number 4 to 17 in the final mark sheet, that is petitioner and his other batchmates from scale 6 cadre, stems from the fact that all of them were promoted to scale 6 in the same year under the same promotion exercise and hence possesses identical tenure in that scale, which determines the seniority equivalence and therefore entitles them to equal marks for seniority. This court finds such submission justified as final determination for promotion is based on comparative merit and seniority on an objective assessment of all parameters in the promotion policy. My lord, though recital is somewhat, my lord, consistent, but what I respectfully submit, my lord, eventually, if your lordship finds that observation made in para 38 is wrong, then my lord, the whole thing will have to go, my lord. Now, is it a fact that seniority is relevant only for determining the zone of consideration? That is what the finding. So therefore, at this stage, what I am praying for is, my lord, lordship will examine this matter. Before the learned single judge, my lord, there was an interim order to the extent that one post they will not fill up. I'm also praying for a similar interim order at this stage, my lord.
My
Lord,
lords, may I send-
I'm sorry, just 1 second.
Sure, please.
Lord, if your lordships will kindly permit me to place para 42 also, my lord, at page 502. A regard being had to the averment made in para 40 of the affidavit in opposition, where respondent to the effect that promotion at such higher level are subjective in nature, given the profile and accomplishment of the candidates, coupled with the requirement of the company, I find the same would be inconsequential as promotion exercise undertaken by the respondent, as revealed from the records, appear to have been on an objective criteria in accordance with the promotion policy for the officers. And Lordship, the learned single judge was trying to overcome that statement of their insurance company, my lord, in their affidavit that at that level it is subjective. My humble submission is, my lord, end of the day, my lord, that observation, if it appeals to your lordship, is okay. Otherwise, my lord, the judgment has to go back. And lordship will have to take a fresh call, because apparently this is wrong, my lord. Because it's a criteria, merit and suitability with due regard to seniority, where each of the component has a role to play. Whether while assessing the petitioner, my lord, appellant, whether this aspect was given a due consideration. That is my humble submission.
My lords, may I please?
Most importantly, clause 7.1 has not even been discussed at all. So it's a composite thing, my lord, compartmentalized thing, where there is hardly any scope of doing a mistake. Every stage, my lord, in fact, it's a very clear-cut policy. There's hardly any scope of subjectivism. It's only objectivism is the motto of this policy. So therefore, my humble submission is, my lord, lordship will examine the matter. And my lord...
It's 7.2.
Yes, my lord.
I was going to start with that, my lords.
Policy, my lord, I'm sorry. Page number
179.
179. Yes. While promotion to scale 6 and 7 shall be based on sole criteria of merit, promotion up to scale 5 shall be based on overall ranking obtained under the various parameters for measuring merit and seniority amongst those qualifying the benchmark prescribed under para 9, provided that in respect of officers for whom the individual KRA have been drawn for an appraisal and or a part thereof during the 6 months or above, on the basis of which performance of the officer has been evaluated for the purpose of PLI scheme or mark. But then, my lord, learned single judge has not taken note of this. Either way, my lord. Had it been a case where having taken note of para 7.2, this conclusion has been arrived at, then it's a different aspect. Even learned single judge did not notice this, my lord. And my lord, with all respect, my lord, 7.1 and 7.2, it has to be read harmoniously. We cannot read 7.2 in isolation.
Selection is always about merit.
Yes.
My lords, may I please submit?
Yes.
My lords, I appear for respondent numbers 2 to 8 in this matter. Though my wakalatnama along with my caveat was only filed for respondent number 3, I will file the wakalat for all of the other respondents in due course, my lords. My lords, if I can just take, my lords, directly to the promotion policy that my learned friend was just reading, and my lords had rightly pointed out 7.2, which is at page 179, my lords. I will only like, my lords, to mark the first line of 7.2, my lords, where it says, while promotions to scale 6 and scale 7, the scale which we are concerned with, shall be based on the sole criterion of merit. My lords, this needs to be marked. There is, my lords, just for the understanding, my lords, scale 1 to scale 5 are the junior posts in this organization, and scale 6 and scale 7 is the top management post. In fact, my lords, scale 7 is the feeder cadre for CMD level, my lords. And my lords, before I proceed with my submissions, the submission regarding any subjectivity is absolutely incorrect. That line had, in fact, my lords, I've stated that before the learned single judge also, that that line is incorrect, and we have shown from record before the learned single judge the entire record of the promotion exercise which the learned judge has perused before passing the order, that there is 100% objectivity in arriving at the parameters, my lords. My lords, for a moment, can have the impugned order, please.
The post is still vacant in terms of the interim order passed.
My lords, so I have a submission. I have a
The
please,
only interim order was, my lord, they will not fill up one
sir,
post.
please let me
Yes.
answer.
Yes, till now it is
No, my
vacant.
lords, my lords, may I
Till now it is vacant.
my learned friend will have to let me answer this question.
Yes.
My lords.
Yes, please.
My lords, on the first date of hearing in the writ petition, a statement was made, and the order records the counsel for the petitioner submits that there is one vacant post. Full stop. If there is a post vacant, the same may be kept vacant until the disposal of this proceedings. This was the order passed, my lords. There was no specific direction to keep one post vacant. Number one, my lords. Number two, my lords, this writ appeal was filed about a week back, served on us. The stay application was not part of the writ appeal. It came yesterday in the evening. It has been filed yesterday by my learned friend. I do not have instructions whether there is now a post vacant or not. I can take that instructions and come back to my lords. But I'm on instructions giving a statement that in case the petitioner does succeed in his petition, we will promote him irrespective of a post being vacant or not. By far, I'm happy. I'm on instruction making that statement. The petitioner's right will not be troubled at all. In case he succeeds, he will be promoted. But for that, we need not keep a vacant position.
Because
Can we quote you?
yes.
Yes, my lords, you can quote me. This statement can be recorded, my lords.
Mr. Kian Chowdhury. Assisted by Mr. S.P. Sharma. Issue. Union. MS.
My lords, I am
Cape Cod. Appears to be. There's thing. Standing counsel. The counsel appears on behalf of respondents 2, 3, and
2 to 8, my lords. 2, 3, 4, 5, 6, 7, 8, my lords.
and 9 to.
My lord, the private respondents, though we made them parties, they never participated in the proceedings before the learned single judge.
The appellants take things. Respondents for 9 to 24. By registered court taking within.
By Monday?
By Monday.
1. This letter see to the official address. Learned senior counsel for the appellants. That there's still a vacant post of in the grade of scale 7. And therefore, the interim operating for the requirement not to fill up Mr.
Zorawar Singh, my lords.
Judge Singh.
That Singh.
Plasma, please.
Leonard Thompson. Agreeing on behalf of the respondent 2 to 8. However, submits that the appellant the respondent would probably happen without the problem like the island. And very true. Recording the submission made by the council agreeing to the response. We are not watching.
My lords, can it please be a fixed date post vacations? I will also like to file my counter to this affidavit in reply.
It is convenient to put up.
Can it be 25th?
My learned friend
please?
give a date, my lord. He'll come from outside.
Can it please be 25th if it's convenient?
14th of July.
25th of July.
It's a Friday. Have it on a Monday, a Tuesday or a Thursday.
Can it be 24th of July then, please?
Yes, yes. Or have it on next week, 29th or 31st.
So that will be not possible for me, sir.
That will be 31st, my lord, of
Sir,
July.
it will not be possible for me, sir.
Or first week of August, my lord, 5th or 7th.
Then sixth, Malaz may have 6th, please.
Okay.
6th, please. Highly obliged.
May it pleases your lordship. Lordship, petitioner is declared as a foreigner lordship. Wide order dated 31/2024. My colleague is there, lordship. This is the reason the other bench cannot take up the matter. This is the reason this is before lordship. Lordship, the petitioner is declared as a foreigner lordship by order dated 31/2024. Thereafter, he preferred a review of the order lordship. But that review order was also, that review petition was also dismissed by wide order dated 21/9/2024 lordship. So petitioner projects herein that his grandfather's name is enrolled or is appeared in the voters list of 1966. His it's in one village, but from 1970 till date, they are in the same village. And his name also appeared along with his grandfather. 1966.
Records have come.
Yes, records are here, lordship.
And who appears on the application?
My colleague.
Respondent number 3, election number 3.
My colleague has gone to call either any one of the council who is there. Yes, my colleague has gone there to call him, lordship. Otherwise, lordship, he has all the documents. 1966, grandfather, grandmother, 1970, grandfather, grandmother, 1977, grandfather, grandmother, father. So linkage is very clear. 97, father, grandfather, father, mother, and the petitioner. These I have annexed along with and even the evidence. And even one of the reasons was stated that he has not disclosed his family details, but which is very well explained in the written statement as well as in the evidence. Even his birth, lordship, although he did not have birth certificate, but his birth was proved through the birth attender who was there because childbirth happened at home. So who was the birth attender at that time, she also has adduced evidence as DW for lordship. Father has adduced evidence, mother has adduced evidence, but still he is declared as a foreigner lordship. And no, there is no rebuttal to any of the evidence which he had led before the learned tribunal lordship.
Notice has been issued.
Yes, lordship. Notice is issued, lordship, because interim was supposed to be considered when records are here, lordship. So this is the reason, lordship. My colleague.
Okay, Miss.
Although my name is not there because I didn't sign the Vakalatnama, my colleague is there. I'm assisting you. SK Chakma is there with me, lordship, whose name is there in the Vakalatnama. Otherwise, my colleague, she would have appeared, but because of some problem, she could not appear before lordship today.
Reports of the received. It's the method for meeting. When?
Lordship, this Friday, lordship. Because Lordship, I'll press for interim, Lordship. Then Lordship, it's up to you, Lordship. Or maybe if it's possible before vacation or post vacation also, it will do, Lordship.
Terry, the fee.
Interim is country.
Shall not be deported.
He is not outside, Lordship. He is not arrested.
Oh.
He can appear before DCP border, Lordship.
Is this better look?
No, Lordship, then I will argue, Lordship, I have a very good case on merit.
Lordship. Opinion was, Lordship, whatever Lordship opinion was passed in the year 2024, Lordship, January 24. So Lordship, it was commonly, Lordship, if one year has been crossed, Lordship, then a common practice was that in other court, Lordship, it was may not be deported till after LCR receipt, Lordship, it will, Lordship, bail will be considered, Lordship.
This is the reason I was pressing for bail today. Records are here, Lordship.
Then-
And even it's not 1 year, Lordship. I have filed review petition and review order is at page, Lordship, 173. By order dated 21/9/2024, my review petition was dismissed, Lordship.
Then Lordship,
I have a very good case on merit, Lordship.
So you'll appeal before the
Yes, DCP border, Kamrup Metro.
important.
Yes.
Normal thing. This after summer vacation.
Lordship.
Deeply very much.
Item 16.
Deep.
We are directed to take steps that we have taken. We have also supplied the memo.
Okay, we are passing this type of this action. You just visit all the parties. The respondent number 3, 6, and 9 shall on or before 21st. But we'll make it 23rd. Huh? On or before 23rd of June 2025. Reverse the defeats made against the saving bank account number two
accounts
of the applicant maintained in the state of India, South Guwahati branch, i.e. respondent number 6. And the State Bank of India SBI
Panbazar.
main branch, Guwahati, i.e. respondent number 9.
Nine.
Okay, respectively. On 9/5. To reverse the defeat of 2000, we created the same to the applicant's saving bank account number so it's maintained with the State Bank of India, Guwahati, South Guwahati branch. To reverse the defeat of 18,68,000 and we created the same to the applicant's saving bank account number. So it's with the State Bank of India SBI Panbazar Bank. Alright. Then respondents 6 and 9 are completing the interest due to the amounts available in the saving bank account of the applicant maintained with them. Shall also recount the amounts debited therefrom on 9/5/2025. Pursuant to directions issued by the Central Pension Accounts CAPO. Respondent number 2. To have remained in the account of the applicant hearing. On recredit of the accounts in the saving bank of the applicant maintained with the respondent 6 and 9. in terms of the directions passed here and above, the applicant would be free to utilize the same as per his discretion. And the respondent 369 shall not pose any hindrance. That is one directive. Number B. Respondent 3, 6, and 9 are granted liberty to approach the CAPO. Respondent number 2, for refund of the amount of the 57 lakhs owed deposited in the account of the applicant. And on approach being made, the respondent number 2 shall facilitate the early refund of the said amount to the respondent specifically. We however clarify that the reversal of the debits paid from the saving bank account of the applicant as per the directions made here and above shall be as per the directions passed here and above shall be made by the respondent number 3, 6, and 9 on or before 23rd of June 2025, and the same shall not be dependent on the refund of the amount by the respondent to CAP. The observations made in the present order having been made only for the purpose of answering the issues arising in the present IA. The same would have no bearing during the consideration of the issue raised okay. That much.
I think that should be. Much of it.
When do you want the writ petition listed?
The Lordship had yesterday said after 4 weeks.
Oh,
Let it come after
yes, the
vacation.
order was list on today. Oh, no. Yes, list on 18th.
After the vacation.
Heard the learned counsel for the parties. List after summer vacation.
Summer vacation.
Okay, list the matter on 25th June. We are listing this on 25th just to see that whether the amount has been recredited by the applicant. After that, we'll fix it.
Hello.